Hi, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana, and if you're new to our firm, Immigration for Couples, our work in the world is that we're dedicated to helping couples across the nation and across the world and navigating the U.S. immigration process. So I already see we have a lot of people live. I had a later start today because I'm trying to connect to Instagram because we have a lot of followers on Instagram too. And so I hope that I did that. I hope I did it right. So if anyone's watching on Instagram, it would be very helpful for you to let me know that you can hear me and see me, and then it's processing live. We had to anyway, technology, a lot of different steps to get that to work. And so hopefully, hopefully I did it right. Good morning, Lisa. It's great to see a lot of our regulars. Please let me know, where are you at in the world? I already have some regulars who know the drill. So Ginger, you're in the UK. Good morning. Good morning, Aguilar. Great to have you. Good morning and morning. So let me know, where are you at in the world? Where are you at currently? I'd love to hear. Like I said, our firm is dedicated to helping couples across the world. And so I love that I can have an appointment with someone in Dubai and then Italy and then Georgia. I love getting to work with people everywhere in the world. And so does our whole team. So we have two Chicago residents here, Hong Kong, Las Vegas. Good morning. Nigeria, Costa Rica. I love Costa Rica. It's been so long since I've been there. Such a beautiful, beautiful country. Good morning, Anna. California. South Africa, New Jersey. All right, keep them coming. I see we have more and more people who are joining. So if you are new to our channel, I want to let you know about our free resources. So we know that knowledge is power. And when you're going through an immigration process, whether you're just starting out or in the middle of your immigration journey, I like to say it's a labyrinth. It feels like you're going through a maze, and it's an alphabet soup is the other thing I say, because for a lot of couples, you're trying to choose between the K1 and the CR1 and what is the right path. So check out our free resources at immigrationforcouples.com. We have downloadable charts. We have a chart that compares the different options that are available. And most importantly, the immigration process, you're proving that your love is real. So I created a guide on how to prove your relationship to immigration, what immigration is looking for. So you can get that downloadable guide at immigrationforcouples.com. And we also have two ways that you can meet with us and engage with us if you are wanting assistance on your journey. So the first option is a free discovery call with Lisa. And Lisa, she's an amazing member of our team. She likes to say she's not an attorney, she plays one on TV. So the free discovery call is an appointment where you learn more about what it looks like to work with our firm. The best individuals who are suited for that free discovery call are individuals who are certain that they're wanting to move forward with the spouse visa or the fiance visa, for example. You have this path in mind, and you want to know what it looks like to have Immigration for Couples be your guide and be by your side in that journey, cost, and our role. And so she will go over all of that in a free discovery call. And then if you are needing specifically tailored legal advice, and I know sometimes individuals have questions here on this live that I answer, and I will say, without seeing that notice that you got from immigration, without knowing more of the details of your application, I wouldn't be able to give you legal advice, but I can do that in a consultation. So you can schedule a consultation with myself, and I'd be happy to give you specifically tailored legal advice, and we can go over, if you're trying to choose between the fiance visa and the spouse visa, we can go over the specifics of your case and talk about what my advice is for your next best steps. Okay, so I will put that up again for everyone to have. I do have a bunch of comments that are coming in. And so for anyone, I love Lisa. You know what? Julie is our firm administrator, and she's helping here moderate today. And so everybody give Julie a shout out. Julie and I were just talking about, we love seeing this community grow. And so yes, it's awesome to see everybody coming here. Gordon, great to see you. Thanks for joining us. All right, Phil, great to see you again. But yeah, it is great to see this community growing. Having gone through the immigration process personally, I know that sometimes you feel like maybe no one understands you, or it just feels like, is where is the finish line? I can't see it. And being in community helps you remember that you're not alone, that other people understand what you're going through. Other couples or experiences this as well. So I love seeing the community grow too. So go ahead and start. Yep, here we have a hi from some members of our team as well. So go ahead and start throwing your questions in. I have a question from Gustavo Oliveira. I am not sure if Gustavo, if you're watching here live, but you had posted a question when we announced the Facebook Live. You had posted a question saying you had two topics that you were hoping that I could discuss, and so that's what I have lined up here today. I'll go over your questions, and then anyone else's questions and comments, I will go through those after. All right. So Gustavo, your question, you said you had two questions for the live, and the first question is the spouse visa easier to get approved than the fiance visa? And I was really excited to see this question because I've been having couples ask this a lot in different ways. And I realized there seems to be a rumor out there that immigration will take you more seriously if you're doing the spouse visa, if you're married, and that they won't take you as seriously with the fiance visa. And there's this rumor that it's easier to get the spouse visa approved than the fiance visa. And the reality is that's not actually true. The fiance visa and the spouse visa both require you to show that you have a bona fide relationship. And what that means is that you have a relationship that its foundation and its core is based on love and not just to receive an immigration benefit. So with the fiance visa, it's a bona fide relationship with an intention to get married. And with the spouse visa, you're married, so it's a bona fide marriage. But one option is not easier in terms of the legal standard or what you have to prove. So it's not easier to get a spouse visa approved than the fiance visa. But it's a great question. The fiance visa does have more steps. It's more complex in terms of the process, but a lot of couples will choose that option if they're wanting an option that is faster, for example, or they definitely want to get married in the United States and they're wanting to have this engagement, or maybe marriage isn't going to be something that will be easy because you have to meet up and organize everything for the wedding, and that can add time to the wait as well. But that's a topic for another day. But choosing between the two, to be clear, choosing between the two, one of them is not necessarily easier in terms of legal standards. So thank you so much for that question, Gustavo. And I know you had a second question. You had great questions. You wanted to know, can someone work remotely, doing work that they do in their home country when they're in the United States? So this is something that comes up, and it has come up a lot. This question has come up a lot since the pandemic because remote work became more commonplace. And USCIS in their policy manual says, and I wanted to pull that up, that unauthorized work, so that's why you're asking this question about remote work, is you don't want to accidentally perform unauthorized work in the US because that's against the law. And so USCIS in their policy manual, they define unauthorized employment as any service or labor that is performed for an employer within the United States by a non-citizen who's not authorized to work. The interesting thing about your question and about current policy and law is it was written well before remote work was a possibility or a thing. And the law and policy, like many laws, with technology changes and life changes, the law as it was written at the time can't take into consideration things that we don't know will happen in the future. So it was written at a time where remote work wasn't a thing. And so it doesn't really speak directly to the policy, and the current law doesn't really speak clearly and directly to remote work and what can be done by an individual while in the United States. There are certain there are guideposts or guidelines that an immigration officer can look at to determine whether or not the remote work is actually unauthorized. So remote work often can be something that is okay if it's a foreign employer and you're doing it on your computer and there's nothing materially different about your work, and you're not necessarily presenting at any conferences, for example, for a US employer, that you're not working for a US employer that would need work authorization. But again, because the law is it's a gray area and there's not a ton of guidance on remote work, it will depend on the specifics of that remote work, of that remote position. Some of the things that immigration officers, the guideposts they look at, what would your tax return say? Is it a US employer? Do you have a W-2? Are you on their payroll? Did you have to be verified through the I-9 verification system? Where is the company, your remote company? Is it stationed in the US or only abroad? So it's a lot of different considerations, a lot of different factors that'll be specific to your particular case and to your particular situation. In general, a lot of our clients are able to perform remote work while they're in the US for a non-US employer who's not located in the US, but it would be a fact dependent or fact specific. So it's a great question, and it's a gray area of law. It's ever evolving, and we're all looking for more guidance from immigration. And I've had conversations with immigration officers about this as well. And yeah, it's just a very complex area of law. So I'm a complex part of our aspect of the law. So thank you for your question. And to be clear, remote work often can be okay, but it really will depend, like I said, on all the specifics of the situation. All right. So now I'm going to pop over to our chat and see what questions we have. Good morning, Mariana. And I don't know. I don't know if I see anyone who's watching on Instagram. So I still don't know if I connected it. It's got a green check. I guess I will find out afterwards if it's on there. And hopefully yeah, at least the law needs to change. We just need some clarity, frankly, is what we need. I understand why unauthorized work isn't allowed. But you're right. There's a lot of areas of immigration law that are confusing or complex or gray area that could be clarified. All right, so let me go to the top here. We have a lot. Good morning, Eds. Okay. Somebody watching from Tucson. Great to have you. Okay. Okay, this is a good question. Your fiance wants to try to come for school. Will that mess up the spouse visa process? So with the spouse visa process, a person has something called immigrant intent, which is a fancy way of saying the individual has the intention to come to the United States to make the US their home and to live. Student visas, tourist visas, certain types of non-immigrant visas are for individuals who are just wanting to come for a short visit for a temporary purpose, such as studying. The thing that gets tricky with having an immigrant visa pending and then trying to apply for something like a student visa is that when you apply, you have immigrant intent, something that you're not supposed to have when you apply for a student visa or a tourist visa. And pretty much all situations, immigration is going to deny that student visa or deny that tourist visa and say, you have immigrant intent, and we know you have immigrant intent because you have this spouse visa pending. But like so many things in immigration, it really depends on the type of student visa and where you're at in the spouse visa process, for example. There's a lot of factors that have to be taken into consideration, but in general, if you have a spouse visa process, that's the process you need to see through to the finish line. But definitely, you can speak with an immigration attorney who works in the area of student visas to get advice on that particular student visa. There are some types of employment-based visas, for example, that have non-immigrant intent, which you're coming for a temporary position for a short amount of time to complete a certain project. And then there's others that have dual intent, like an H-1B for specialty workers, who that wouldn't mess up the spouse visa process. So it really, really, really depends on the type of visa for which you're applying. All right. Let's see. Oh, you said sorry to jump in so fast. So good morning, Andreas. Sorry to jump in so fast. That's fine. Get your question in there because we've had so many viewers and so many questions come through that I can't always get to all of them. So jump in there. Okay, so you have a girlfriend in Cuba and with 2 minor daughters. Is it best to marry in Cuba or to marry here in the USA before the 90 days with the visa? I'm also worried about separating the family. Okay, so let me get my bearings straight. So it sounds like you are dating, but you're considering marriage and that you haven't filed anything yet, and you're wanting to know is it better to marry there or marry in the US before the 90 days with visa? So I'm not sure where they're at currently, but it sounds like you're wanting to do the spouse visa. I'm not sure if you're asking of choosing between the spouse and the fiance visa. But let me back up. This is a complex question without knowing everything about your situation. So I want to start with adjustment of status because that's where I'm seeing some part of your question that maybe there's some confusion. So there's something called adjustment of status. I'm not sure if you're asking about that, but adjustment of status is a process that's available to individuals who are in the United States, in a relationship, married in the US, for them to be able to go from, for example, a student visa or a tourist visa to a green card and complete the whole process in the US. It's a very popular option because you get to be together. The whole process is completed here in the US without you having to leave or be apart. It typically is a faster process, but the kicker with the adjustment of status is that an individual can't come to the US on a tourist visa or student visa, for example, with the intention to get married, stay here and live and remain. Because as I said earlier, a tourist visa, for example, is non-immigrant intent. You can't come here with that intention to marry. So with that in mind, adjustment of status isn't available to someone who comes on a tourist visa with that intention. But if you're asking about just getting married to be able to start the spouse visa process, if you're asking about getting married in the US or in Cuba and then starting the spouse visa process, and if you're saying, hey, I want to get married in the US, but my spouse is going to leave, then it would leave and then start the spouse visa process, then that wouldn't be running into an issue with adjustment of status. So that's a long, a long backdrop because I always want to be very careful to be clear. I am not giving legal advice. You definitely want to meet with an immigration attorney, be it myself or another attorney, to go over all of the specific facts of your case to make sure you're picking the best path and the path that is, of course, lawful. So it's completely fine, though, for individuals to get married in the US and then their spouse would depart the US and then you could start the spouse visa process. That process all happens abroad. And so that's fine to get married in either country, just making sure you're not having issues running into intent with that adjustment of status. So I hope that helps. I hope that's as clear as mud, as clear as immigration can be, Reyes. Thank you for the question. Okay. Um, So your fiance is in Pakistan and he's from Afghanistan, don't know where to start. So if you are thinking of doing the fiance visa process, the first step is to make sure that you meet all of the eligibility requirements for the fiance visa. And then the very first step of the process is filing a petition. So I highly encourage you to check out, I'll put that up here again, our free resource center at immigrationforcouples.com. We even have a free webinar that goes over this very question, where do I start? And I talk in the webinar about all of the different options, the 4 options that are available to couples, eligibility requirements, proving your relationship. And so that it would be a really great place for you to start at immigrationforcouples.com. And if you're at a point where you're needing legal advice and wanting to pick a path and understand your next steps and the best path, you can always call our office and get scheduled for a consultation. All right. Let me jump back over to my questions here. Can you travel to Canada? You're a Canadian citizen while request for evidence is pending and combo card is approved. So I'm understanding that you have an adjustment of status and that you applied for your work permit and your travel authorization and you've received those and that you're wanting to travel. Because if you have an adjustment of status case pending, you can't travel while your adjustment case is pending unless you have that travel authorization. And can you travel while a request for evidence is pending? Legally, yes. From a risk perspective, it's always important to understand what is the request for evidence. Is it for your relationship? Are they really calling into question some aspects of your case that if you aren't able to prove those aspects, like prove your relationship, for example, or prove your eligibility, if you're not able to do that and they deny your case while you are in Canada, then there's that risk that exists of not being able to re-enter. So without knowing what the request for evidence is for your case, I would err on the side of caution and say there's that risk can exist with traveling when that request for evidence is pending. I don't know if you've responded yet, but in general, it's always safer to stay put and wait for that green card. But legally, if you have a travel authorization, you're legally able to travel while that adjustment's pending. So again, I know that I can't give you the conclusive yes or no. In general, it is fine to travel if you have a travel authorization, but it will just depend and putting in and balance risks associated with that request for evidence. All right. Okay. So after the K-1 visa, do you apply for an I-45 or do you apply for both the I-130 and I-485? This is a question that gets asked a lot, and it's one of the common missteps that I see for couples who are doing the case on their own. So I'm glad that you're asking, is that they will file forms that aren't needed. And so when you're doing the fiance visa process, that very first step is a petition where you're proving your relationship and that you meet the eligibility requirements. And then once you enter the US on your fiance visa, you need to go through an adjustment of status process, which is that form I-485. The I-130 petition is for spouses. And so once you enter on the visa and you're married, you would be a spouse at that time. But filing an I-130 is not required unless you didn't get married on time or you didn't meet certain requirements. Sometimes the I-130 can still be required. But in general, you've already had that petition approved, so you wouldn't need to file the I-130 again. And if you did and you paid for it, I said this on the last live, immigration will take it. They'll take your money. They won't let you know, hey, we didn't need this. And then if later, if you realize, they'll be like, well, you paid for it. We're not going to refund you. So I'm glad you're asking before you start paying immigration, because they'll definitely take your money if you file for it. So in general, that I-130 is not needed. All right. Good question. Okay, so Chuck, you're planning on your picture. It's a very adorable, the little hand pointing. I like that. So you're planning to meet my fiance in the Philippines for the second time this September. Will this help the process? So that's great. Meeting in-person meetings, proof of meeting each other, having trips and visiting one another, that always helps to strengthen your relationship evidence and show you have a real relationship based on love. I'm not sure if you've already filed your petition, or if you were having this meeting to meet that 2-year in-person requirement. But yeah, traveling to visit one another doesn't hurt. And with the fiance visa process, you have to prove your relationship multiple times. You have to prove it with the petition. You have to prove it at the interview. You have to prove it with your green card application. Then if you get scheduled for another interview. So keep collecting the evidence. That will be very helpful. Okay. Yeah, John, this is a really good question too. Everybody's on fire with their questions today. So there seems to, you said there's confusion about the online marriage through Utah County. Despite the couple being present on the Zoom call, do they still need to show that they're together physically after marriage, even though they've been physically together prior to the marriage? So I actually was just recording a bunch of video content last week, and I talk about this specific question, but I'll answer it here too. And that video will be posted here in the coming weeks. But there is confusion, and USCIS, this is another area of immigration law that it was written before the Utah virtual marriage was even in existence. So immigration has a law in place for proxy marriages. And so proxy marriages is a very, something from like medieval times, if you haven't heard of proxy marriages, where prince and princesses needed to get married. So they were far away, and someone would stand in as a proxy for the bride or the groom who wasn't present to be able to have that marriage be legally binding. So immigration has a law on the books for how they treat proxy marriages. And for individuals who are married by proxy, because that still exists at present day, they have to show that they have been physically together in each other's physical presence after the marriage to show that there was the consummation of the marriage. And with the Zoom weddings through Utah, immigration has really been treating those like proxy marriages, even though they're not proxy marriages, they're virtual marriages. And we always want to prove that consummation requirement. In general, I encourage my couples who are going to get married through Utah to be physically present with each other for that Zoom call, to be in the same place and then show you were together after the wedding to be safe. So to be clear, I know there's a lot of rumors out there that, oh, well, I haven't been able to meet my spouse in person. I can't go and meet them in person for the fiance visa for that requirement. We could do this virtual wedding. We're in two different places, but immigration will give pushback for sure. But I know you said, that you're meeting prior to the marriage, but the safest bet, especially with immigration, not really making a clear distinction between virtual and proxy marriages. And I know for a fact that immigration's really been treating those, like I said, like a proxy marriage, meeting, being in person for that virtual ceremony and together after is really the best bet. So great question, John. And yeah, great question. And I'd like that. Like I said, that video will be out here in a few weeks too. So, all right. Okay. All right. So I'm gonna get a drink. I'm struggling here a little bit from talking and read the question at the same time. Okay. So we met twice with my fiance and we were ready to apply for the fiance visa. Do I have to prove the relationship or my fiance should bring all the evidence? Well, congratulations on meeting and congratulations on getting started in the process. The very first step of the process is a petition that you file with immigration to prove that you have that real relationship based on love, to prove that the petitioner is a US citizen, to prove that you've met in the past 2 years, to prove that you're legally free to marry. And then they also look at the petitioner's criminal history. So those are just like a 30,000 foot overview of everything you're proving with the petition. And so the answer is yes, you have to prove the relationship with that petition. And then you have to, as I said earlier, you actually have to prove it at multiple steps. So you'll have to keep collecting evidence. All right. I invite you again to check out, I'll pop that back in here, immigrationforcouples.com. I invite you to check out our downloadable guide that goes over the fiance visa process and outlines the steps. And then we have that relationship evidence guide that I encourage you to check out as well. It's immigrationforcouples.com. Okay. So great question. And congratulations again on your relationship. That's very exciting. All right. I like that. Love is the answer. I like that name. That's perfect. So your son is married, has a child together, got a temporary green card, but spouse left. Oh, I'm really sorry to hear that. But spouse left with a child, almost 3 years of marriage. Marriage didn't work out. Now green card and work permit are expired. So it depends on the type of green card that he has. So there's something called a 2-year green card, a conditional green card, and then something called a 10-year permanent green card. So the 2-year green card is conditional based on that person's marriage. So if the individual was married less than 2 years at the time of receiving their green card, immigration will give them a conditional green card. And immigration wants to check in with that person closer to the 2-year mark and see that they're still married and in love and have a bona fide relationship. Unfortunately, relationships, things happen, divorce can happen. Separation can happen. If the relationship doesn't work out, there's still a way for the person to keep their green card, and they have to go through a process of you file what's called removal of conditions, and you ask for a waiver of that requirement that the couple file together. And so our firm has helped many individuals, hundreds of individuals, with that specific process successfully be able to keep their green card. It's a more complex process because when you're not together and you can't prove, you don't have that proving that bona fide relationship because the couple isn't together, it can become more complex. So if that's the situation and they're needing legal advice, please check out immigrationforcouples.com and schedule a consultation. And we also have a section about removal of conditions and that 2-year requirement and that waiver. There's some videos on there that talk about that as well. So yeah, and that was the other part of your question, what can he do? So, like I said, check out our website. And then if he's needing legal advice and then having an attorney help with that process, we'd be happy to help. Again, I'm sorry to hear about the situation. That's very difficult. Oh, that's great. You're both here watching. I love that. Good morning, Pooja. It's great to see you again. Oh no. Okay. So so you said, is there something that is there's still something that can be done once your application is denied. You read in one of the forums that a couple's application got denied because the lawyer submitted the wrong required copy of the marriage certificate. So it depends on whether or not the person's getting a request for evidence or a notice of intent to deny. It depends on what kind of notice the person received. Typically, with a notice of intent to deny, there's still an opportunity, and that's the final opportunity to save the case. If you don't respond properly to that notice, then it will be a final denial. Immigration has ways to appeal, but the appeals process is much different and usually than other areas of law, and it usually has to be an appeal based on immigration's error. So the short answer is yes, there is oftentimes ways that that case can still be saved. If it's that notice of intent to deny, usually immigration gives you a very short amount of time to respond. But it's, I know that you're giving the second hand. We don't know all of the details. It really depends on the marriage certificate as well, because whether or not maybe the marriage wasn't registered. I'm just kind of speculating about possible issues. And so if the marriage wasn't properly completed and it wasn't registered and it wasn't legally binding, then there wouldn't be a way to save the case. So it really just depends on the type of notification immigration was providing, and then of course, as always, the specific facts of the case. But typically when individuals come to us that have maybe done their own case or in a situation like this, typically there's a way that we can still save the case, and if we can't, we'll be honest about what are the next steps. All right, so great question. Okay, so he applied for the renewal papers, but it got sent back. So this is on the removal of conditions. It sounds like he does have a removal of conditions case. So a renewal application is not the right process. And that's why definitely let's, have him get on a call with our firm. I'd be happy to speak with him. He can send over any documents that he has and I can take a look beforehand. And then, I'd be able to go over options with him in a legal consultation. So he'll want to schedule that consultation at immigration4couples.com. Okay. Oh, hey, Phil. And Ian sends her regards. That's great. You're enjoying your 4 months together in the US. Wonderful. No issues with entry. I love to hear it. I know that's always nerve-wracking with coming back and forth to visit and having immigration wonder, what are your intentions? So that's wonderful. I'm so glad that you're able to be here live today and that you're together. Enjoy that time together. All right. Okay. I'm legally married in the Philippines, but separated from my ex for 17 years. I've been living in Thailand for 10 plus years and I'm getting a Thai divorce. Will America accept the Thai divorce for a K-1 visa? So that's something that's makes immigration law complex and also for me particularly fun and interesting, and for a lot of members on our team, is that overlap between there's US immigration law and then the overlap or intertwining of laws of other states and other countries. And so the Philippines is so unique because the Philippines and the Vatican are the only two countries in the world that don't recognize divorce. You have to get an annulment. And so individuals who have been married in the Philippines, and then if you get divorced elsewhere, you have to register. This is Philippines. This is the law of the Philippines. You have to register that divorce in the Philippines because part of the immigration process, when you get to your consular interview for your fiance visa, when people ask, hey, what is the list of documents that I need to take to my consular interview? There's a general list, but every case is so different. And the country where the person is from could also add other documentary requirements. So with the Philippines specifically, there's something called a CENIMAR. Anyone who's going through the fiance visa or spouse visa process has to obtain a CENIMAR, a certificate of no marriage. So if you are married in the Philippines, you won't be able to get that CENIMAR. You'll have a CMAR, that it's a certificate that you are married. And immigration, because it's a requirement of the government, of the laws of the Philippines, U.S. immigration will also require that document, so you can be in compliance with both places. To be clear, I am not licensed to practice law in the Philippines, Filipino law. I practice US immigration, and so I can represent clients with the US immigration process. But when it comes to the CENIMAR and registering of marriages and registering of divorces in other countries, that's something that you would need to hire an attorney from the Philippines to help with registering that divorce. So, great question. I'm glad that you're asking that. Yes, US immigration will accept your divorce document, but you'll also need to have documents from the Philippines as well showing that that divorce was recorded. So, great question, and I highly encourage you to talk to a lawyer there to make sure everything is registered, because I know that that can be a long process. All right. Um Okay, let me grab a question. Get my we have 48 people watching here live. That's awesome. I don't see anyone on Instagram, so I'm still not convinced I did that right. I shall try again next week. We'll see. Can I briefly describe the spouse visa process? Absolutely. So I can do my what I call my 30,000-foot view of the process. So I like to break immigration down into more digestible steps. And the very first step is a petition where you prove your relationship to immigration. And then after that petition is approved, your case will move on to the National Visa Center. That's step two. The National Visa Center, they're a glorified document collection agency, and their job is to have you turn in all of your documents so they can say, yep, everything is here from the checklist, and then send your case on to the US Embassy or consulate where the interview will occur, which is step three, that consular interview. And it's at that interview where you'll get a final decision and the visa and to be able to enter the US. And you could look at that really as step four. Once you've entered the US and landed in the US, that green card will come in the mail. If you want to see more about the spouse visa process, as I said, we have that free resource center at immigrationforcouples.com. And I go through the spouse visa process, that 30,000-foot view, but in a little bit more detail. All right. Thanks for the question. You're very welcome. Bummer. Thanks, Lisa, for checking. I appreciate it. I will have Julie is awesome with technology and our tech company, and we will figure that out so that can happen next time. I was really proud of myself. I thought I had done it. Thank you for checking. Um, so is there okay. So basically it sounds like you're wanting to maybe transfer your case to a different consular post. So if that's the question that you're asking, uh, you can ask another consulate, another US embassy or consulate if they will accept your case to do the interview. But it's up to their discretion if they will accept that request. Certain countries require you to have a certain status in that country to be able to have your interview there. So it will really depend on the specifics of your situation and your particular case. But you'd have to reach out to the consulate where you want to have the interview to ask if they can accept it. All right. All right. Goodness. Let's see. The hour is flying by today. We have so many great questions. I'm not sure, Christine, I'm not sure if I understand. Um, I'm not sure if I understand fully your question. I'm not sure if you're asking or saying that you filed an application and paid and you haven't gotten your receipt notice, or if you filed and paid and have your receipt notice and it's taking a long time. I'm not totally sure if I am clear on your question. If you've paid and haven't gotten a receipt notice and you see that the fees have cleared, definitely you can reach out to immigration. If your case is taking a long time, wait times are can be long in immigration. It depends on your case type. Some cases, depending on how long you've waited, you can go through a process called a mandamus action to sue the government to do their job. Our firm handles those as well, but without knowing if I'm understanding your question completely, just giving you kind of some general information. Hopefully that helps. Okay. So, Gordon, you said your wife's been waiting for her green card approval since March of 2022. The work permit expires September, and you're going to apply for the EAD renewal. That's a very good idea. And you applied for the I-45, advanced parole, all at the same time. And then your understanding is there isn't a fee for renewal of EAD in this case. Am I correct? You're awesome. Oh, I love having you here. I'm glad that you've enjoyed the sessions. Yeah, employment authorization renewals for adjustment of status for this type of case do not have a renewal fee, but the great thing that you can use a tool. I can't believe I'm saying immigration. USCIS is a tool that I like. Usually a lot of their tools are not very helpful, like processing times, but they do have a fee calculator tool. And if you go to their USCIS fee calculator tool and put all of follow the prompts, the type of application, it'll tell you exactly what the fee is, so you can have peace of mind knowing that you're doing it right. However, the thing that stands out to me the most is that you've been waiting 2 years for the green card, and that's a very long time. I don't know if you've had your interview or if you've had requests for evidence, but in cases like that, where it's been a 2-year wait or more, our firm files something called a Mandamus action. They are a very effective tool. I'm licensed in Washington, D.C. as well, just so I can actually file these lawsuits against immigration so they can do their job. And typically we file those mandamus actions, and shortly after, our clients have an approval or a decision. Being clear, a mandamus action gets the government to do their job. It doesn't guarantee an approval, but if you've been waiting that long, I think if you don't have an attorney, I really think that's something you might want to look into. So if you're wanting assistance with that, please feel free to schedule a consultation and we can talk about what that looks like. Otherwise, I'm glad you're renewing the work permit, and you're always welcome to continue waiting if that's your prerogative. But I'd be remiss if I didn't tell you about that arrow that we have in our quiver to get the case moving forward. All right. So should you trust the dates on the website? It says 3 months for processing. So I'm not sure if you are meaning the USCIS processing times tool where it just gives that estimate, or if it's in your online account. So I know the online account has been doing this thing where they have like a countdown, and you start to get excited and you think you're a week away or a month away, and then all of a sudden it says case is taking longer than usual to process. The dates on the website, they're an estimate, and that's all immigration really is able to provide us, is with an estimate, because there are so many factors. So usually the estimates are very helpful. But I would want you to always, like I tell my clients, be mentally and emotionally prepared for it could possibly take longer. So, but hopefully it's right, and hopefully you get that decision soon. Okay. So you have a question. Your girlfriend's in the Philippines and you want to do the fiance visa. And we were wondering, once we finish the process, when can she stay permanently here? So the fiance visa, the process allows you or her to get that visa to come to the US. And then once she enters with that visa, then you have 90 days to get married. It's once she enters the US on that fiance visa that she's able to stay here and live legally and permanently. You have to get married, though, in 90 days, and then she'd have to file her application for her green card, which is the lawful permanent resident status that allows a person to stay here and live. All right, great question. And I encourage you to check out our resource center too at immigrationforcouples.com. Okay. Oh, you said your interview with the consulate was scheduled for May, but just got rescheduled to July. I'm disappointed. How often does this happen? I'm sorry. I know that's so frustrating to be all excited and then have it get rescheduled. Yeah, it happens infrequently. It doesn't happen a lot, but it has to do with their schedules. Sometimes they maybe make a mistake and overbook, or they had a change and maybe one of the officers left their position. There's a lot of different reasons why that can happen. In some situations, they might have wanted more time to look at your case. Sometimes they haven't gotten the physical file. There's a whole long list of reasons it could happen. I know that that's disappointing, but just try to stay in gratitude and be in gratitude that at least it's in July. At least you can see the finish line, and best of luck at your interview. I hope it goes well for you. Okay. Okay. All right. So you sponsored your dad's visa application 5 years ago, but he hasn't been called for an interview. My lawyer said that the case is in Cambodia. What should I do? So that's a long wait for a U.S. citizen petitioning for their parent. It would depend on where you're at in the case. I would want to check and make sure that everything with the National Visa Center was properly completed and that he's in queue, actually in line for an interview. Because if not, that could hold the case up. There's a lot of different reasons why that could happen. Definitely talk with your attorney and get more details on where you're at in the process and what the next steps are and what their intel is or what their thoughts are on why the case hasn't been scheduled for an interview. And if you're looking for a second opinion, I'm happy to speak with you in a consultation. And like I said, you can send over documents and we can take a closer look about what might be going on and what's causing the delay. All right. Awesome. Julie put that in there for everyone. The resource center. Thank you. That's awesome. Awesome. And she put it on Facebook. Okay. Sharon, so a consultation with an attorney with myself, we charge $300. And then if you decide to hire our firm to represent you with your case and be your guide, that $300 will be credited to the cost of your case if you hire within 14 days. And you'll see all of that on our website, immigrationforcouples.com. All right. Okay. So, and you're wanting to know, I don't know if there was another part to your question that I missed, but it looks like should I go here and marry him? I'm in Pakistan. So it sounds like you're asking one of the most popular questions, should I do a fiance or a spouse visa? And I know nobody likes the lawyer answer, it depends, but it really does depend on what are your goals, your specific situation. Oftentimes individuals will pick the fiance visa because typically it's a little faster than the spouse visa. On the flip side, though, individuals will choose the spouse visa option because they want the ability to work immediately upon arrival. Those are usually the two factors that the couples are looking at the most in choosing between the two options. All right. And definitely, you can check out our free resource center, immigrationforcouples.com. And we have a chart that goes over the 4 options that are available to couples. And it has those 2 options specifically. And so you can get more details and more information to understand the different paths that are available. Oh, you forgot to mention it's the I-130 petition for your wife. So 3-month wait would be awesome. To be determined. For most spouse petitions, the very first step, you're looking at more like a 10 to 12-month wait for the first step, give or take. Wait times are fluid and change daily. But yeah, that would be great. I hope you get a decision in 3 months. That would be cool. It'd be nice to be together sooner, right? You're very welcome. Okay. So do you need an I-130 for a CR1 visa? So the CR1 visa is the spouse visa. And yes, the very first step is a petition. And that is one of the forms that you file with the very first step to begin the process. Here's another question. So Marcy, your son's fiance arrived in the US on a K1 visa on March 4th. Awesome. Congratulations. Super exciting. She's received a social security card and their marriage license. She's been offered a job to pay her on a 1099. Is this okay? Well, that kind of, I don't know if you were here for the beginning when we were talking about remote work. That gets tricky. So I'm guessing that they are filing or they have filed or getting close to filing that adjustment of status application. The best bet to be in compliance with the law would be to wait for that work permit to arrive. That's always the difficult part with the fiance visa. I can't say conclusively yes that she could work on a 1099. It depends on where the company is located and if this is the type of job that is typically a contract position. But without knowing that, I can say conclusively that it's typically best, like I said, to wait for that work permit. So hopefully they've applied for their adjustment of status case and have filed for that work permit. We have been seeing work permits coming as soon as 2 months. I hopefully that holds true. We've seen that for many clients. It can take longer than that, but once she has that work permit, she is clearly at that point when someone has that work permit in their hands, authorized to legal work. And at that point, it would be a safer situation. All right. To be in compliance with the law. That's everybody's goal, right? um, okay, this is a great question. I have a couple minutes left. So, do you think the letters from family and friends are necessary for a CR1 case if the sponsor and beneficiary met many times and were together more than 6 months and 2 years and have joint bank accounts? So, letters from family and friends are nice. They can be a very helpful piece of evidence, and each each relationship is unique. That's one of the many things I love about my job, is getting to see each couple's unique story of love and how they met and proving that love is real to immigration. Are they necessary? It really depends on all of the other evidence, what all of the other evidence looks like, because I always like to look at what we're submitting to immigration as a story, like I said, a story of love. And if an immigration officer were to look at this case and see that particular evidence, because for example, with bank accounts, it's great to have a joint bank account, and it needs to be an account where there's actual activity. I don't know what your account looks like. I assume that there is, but things like a direct deposit going in or joint bills being paid, that it's an actively used account. And then, photos, I assume you have photos together and proof of your travels. That could be enough, but really, so I can't say yes or no fully. I say letters of support are great. Having one or two letters of support is always helpful to round out your evidence. I would say check out our free relationship evidence guide at immigrationforcouples.com. And I talk about the Goldilocks standard of, that the Goldilocks story, right? Of wanting things to be not too much evidence, not too little evidence, right? Right in that sweet spot of proving your story of love is real. And in that relationship evidence guide, I talk about what immigration officers are looking for, their fraud investigation unit, different types of evidence, and how to really have a solid, rounded out case with relationship evidence. So yes, they would be nice. They would be nice to have. It doesn't hurt. It depends on if you have enough other evidence to prove your case. All right. It sounds like you have a lot of strong evidence though, and that you've been together for a while. So that's very helpful. Good luck with your case. All right. I just went through the list of questions. There's so many. I'm sorry I can't get to all of them today. I'd love to. I think I'd have to be here for 8 hours to go through all of these. Good morning, Maria. I wish you're very welcome. I'm going to see. I'm right at the top of the hour. I'll do one more question. And then Gordon, you said you paid the I-485 fee. That's good. That's awesome. I'm glad you paid that. Okay, I'm going to grab this question. What happens if a previous immigration based marriage failed during the 2-year conditional? The immigrant leaves the US and 10 years later, the immigrant is marrying another US citizen. That is going to be a more complex case. Immigration is going to look back at that prior relationship when they're looking at the new relationship. Because when they're looking at the new relationship and they're wanting to determine that relationship is bona fide based on love, the thing that becomes more complex about this situation is they're not going to look just at this current relationship. They're going to also look back at that prior relationship to see, was that relationship real? Was there marriage fraud? And they're going to look at that in determining whether or not to approve this current case. Okay. It was so wonderful to be with all of you. Thank you so much for all of your great questions. I will be live again next week at a different time, so stay tuned. We will let you know the day and time. If you're watching this on the replay, do a hashtag replay and let me know your questions. I will go through these other questions that I wasn't able to get to, and I can use them as starting topics for next week. Otherwise, feel free to join next week. Like I said, we'll announce the day and time, and then jump in and ask your question. And I'm happy to go over them with you. All right. You're very welcome. All right. Have a great day, everyone. We'll see you next week. Take care. Bye.